Rule 69, Partition. Section 1, Complaint and Action for Partition of Real Estate. A person having the right to compel the partition of real estate may do so as provided in this rule, setting forth in his complaint the nature and extent of his title and an adequate description of the real estate of which partition is demanded, joining as defendants all other persons interested in the property. Section 2, Order for Partition and Partition by Agreement thereunder. If, after the trial, the court finds that the plaintiff has the right thereto, it shall order the partition of the real estate among all the parties in interest. Thereupon the parties may, if they are able to agree, make the partition among themselves by proper instruments of conveyance, and the court shall confirm the partition so agreed upon by all the parties, and such partition, together with the order of the court confirming the same, shall be recorded in the registry of deeds of the place in which the property is situated. A final order decreeing partition and accounting may be appealed by any party aggrieved thereby. Section 3, Commissioners to make partition when parties fail to agree. If the parties are unable to agree upon the partition, the court shall appoint not more than 3 competent and disinterested persons as commissioners to make the partition, commanding them to set off to the plaintiff and to each party in interest such part and proportion of the property as the court shall direct. Section 4, Oath and Duties of Commissioners. Before making such partition, the commissioners shall take and subscribe an oath that they will faithfully perform their duties as commissioners, which oath shall be filed in the court with the other proceedings in the case. In making the partition, the commissioners shall view and examine the real estate after due notice to the parties to attend at such view and examination, and shall hear the parties as to their preference in the portion of the property to be set apart to them, and the comparative value thereof, and shall set apart the same to the parties in lots or parcels as will be most advantageous and equitable, having due regard to the improvements, situation, and quality of the different parts thereof. Section 5, Assignment or Sale of Real Estate by Commissioners. When it is made to appear to the commissioners that the real estate or a portion thereof cannot be divided without prejudice to the interest of the parties, the court may order it assigned to one of the parties willing to take the same, provided he pays to the other parties such amounts as the commissioners deem equitable, unless one of the interested parties ask the property to be sold instead of being so assigned, in which case the court shall order the commissioners to sell the real estate at public sale under such conditions and within such time as the court may determine. Section 6, Report of Commissioners' Proceedings not binding until confirmed. The commissioners shall make a full and accurate report to the court of all their proceedings as to the partition, or the assignment of real estate to one of the parties, or the sale of the same. Upon the filing of such report, the clerk of court shall serve copies thereof on all the interested parties, with notice that they are allowed 10 days within which to file objections to the findings of the report if they so desire. No proceeding had before or conducted by the commissioners shall pass the title to the property or bind the parties until the court shall have accepted the report of the commissioners and rendered judgment thereon. Section 7, Action of the Court upon Commissioner's Report. Upon the expiration of the period of 10 days referred to in the preceding section, or even before the expiration of such period, but after the interested parties have filed their objections to the report or their statement of agreement therewith, the court may, upon hearing, accept the report and render judgment in accordance therewith, or for cause shown, recommit the same to the commissioners for further report of facts, or set aside the report and appoint new commissioners, or accept the report in part and reject it in part, and may make such order and render such judgment as shall effectuate a fair and just partition of the real estate or of its value, if assigned or sold, as above provided between the several owners thereof. Section 8, Accounting for Rent and Profits in Action for Partition. In an action for partition, in accordance with this rule, a party shall recover from another his just share of rents and profits received by such other party from the real estate in question, and the judgment shall include an allowance for such rents and profits. Section 9. Power of guardian in such proceedings. The guardian or guardian ad litem of a minor or person judicially declared to be incompetent may, with the approval of the court, first had, do, and perform on behalf of his ward any act, matter, or thing respecting the partition of real estate which the minor or person judicially declared to be incompetent could do in partition proceedings if he were of age or competent. Section 10. Costs and expenses to be taxed and collected. The court shall equitably tax and apportion between or among the parties the costs and expenses which accrue in the action, including the compensation of the commissioners, having regard to the interest of the parties, and execution may issue therefore as in other cases. Section 11. The judgment and its effect. Copy to be recorded in Registry of Deeds. If actual partition of property is made, the judgment shall state definitely by metes and bounds and adequate description the particular portion of the real estate assigned to each party, and the effect of the judgment shall be to vest in each party to the action in severalty the portion of the real estate assigned to him. If the whole property is assigned to one of the parties upon his paying to the others the sum or sums ordered by the court, the judgment shall state the fact of such payment and of the assignment of the real estate to the party making the payment, and the effect of the judgment shall be to vest in the party making the payment the whole of the real estate free from any interest on the part of the other parties to the action. If the property is sold and the sale confirmed by the court, the judgment shall state the name of the purchaser or purchasers and a definite description of the parcels of real estate sold to each purchaser, and the effect of the judgment shall be to vest the real estate in the purchaser or purchasers making the payment or payments free from the claims of any of the parties to the action. A certified copy of the judgment shall in either case be recorded in the Registry of Deeds of the place in which the real estate is situated, and the expenses of such recording shall be taxed as part of the cost of the action. Section 12. Neither paramount rights nor amicable partition affected by this rule. Nothing in this rule contained shall be construed so as to prejudice, defeat, or destroy the right or title of any person claiming the real estate involved by title under any other person or by title paramount to the title of the parties among whom the partition may have been made, nor so as to restrict or prevent persons holding real estate jointly or in common from making an amicable partition thereof by agreement and suitable instruments of conveyance without recourse to an action. Section 13. Partition of personal property. The provisions of this rule shall apply to partitions of estates composed of personal property or of both real and personal property in so far as the same may be applicable.